Right, because I think it's very, very important that we debate these issues, because for far too long in this country, issues like these were never debated or discussed in sort of, relatively speaking, public forums. People might have had views and opinions that were kept, for all intents and purposes, in a very private way, in a private sense. And I think it's important that we debate and discuss them, and if we disagree about them, we disagree about them. I'm very glad to see that Tom's here. I've shared a platform with Tom before in relation to this particular issue, and I'll be really interested to see what he has to say. I suppose just to start out, I think the issue, the starting point for my particular position would be the Fleming case. And I acknowledge the fact that the Supreme Court did not recognise that there is a constitutional right to die or a constitutional right to assisted suicide. The Supreme Court did not acknowledge that particular right. Of course, the Supreme Court, as it does on many occasions, expresses large degrees of sympathy for people's situations and expresses views and opinions about people and acknowledges that their particular situation and issues in relation to dignity. That is important. But what the Supreme Court did recognise, and it's important to appreciate this, is that it did recognise that Parliament does have the capacity to legislate for assisted suicide. So it didn't say this particular issue is completely out of bounds. It acknowledged the fact that the Parliament, and many courts in the world have pointed this out, not only in relation to issues in relation to this particular issue, but recently if we look at the surrogacy case before the Supreme Court clearly lays the responsibility, even if the judgment hasn't been handed down. You can see, I guarantee you there'll be a criticism of the failure of the legislature to regulate particular areas. Now, obviously, if Parliament ever makes up its mind and makes a decision to legislate for this particular area, that piece of legislation could be challenged in terms of failing to protect, for example, the right to life, the right to dignity and the sanctity of life. The main plank of my argument here today really is about the idea of the autonomy, the concept of autonomy. Again, I acknowledge the fact that the Supreme Court did not acknowledge that the right to autonomy under the Irish Constitution extended so far as to allow or to permit for assisted suicide. It did, though, I think, recognise that autonomy, from both a legal and an ethical perspective, is an important principle. And I think we have to bear this in mind, that when we talk about this particular principle, what exactly are we talking about? And I think the way I look at it, in terms of how I look at the principle, it's, from a lawyer's perspective, people talk about autonomy as if it's about making autonomous decisions, and it's all about decision making in some senses. So the focus is always about the decision. And I don't look at it in that particular way. I look at it in terms of a quality of life, or the right of an individual to determine how they live their particular life. That's the way I look at it. Now, obviously, as with many principles, both legal and ethical, it's not absolute, and there are obviously situations and circumstances where an individual cannot exercise their autonomy to the detriment of somebody else, and that's very well clearly recognised. So I think in terms of, it's about people making decisions about the lives they want to lead, and also in certain circumstances, and in relation to the issue of assisted suicide, maybe the life they no longer wanted to lead, because ultimately the issues of quality of life are essential to the concept of autonomy. Because ultimately, in terms of the quality of life that one leads, is a very, very, very personal, value-driven view and opinion. The difficulty with the motion, of course, is that when we talk about the concept of allowing for assisted suicide, we're getting into very tricky areas. We're going to hear about maybe positions in relation to slippery slopes and floodgates, that if we allow and permit this particular type of assisted suicide, where does it end? And I'll be very clear and nail my colours to the mast from the beginning. I believe that the right should be respected within a legislative framework, but I would require, for example, that right can only be exercised in circumstances in relation to a person that is conscious and is competent. I'm not going to limit to adults. I thought about this on the way here today, because there are circumstances, for example, for adolescents, where adolescents have been shown to have the maturity to make decisions for themselves. And there's been lots of research done, for example, in Canada and Australia about children, terminally ill children, and about their ability to make decisions about their particular treatment, and in circumstances deciding not to have any further treatment. So I think if a person is conscious and competent and they have the ability to make the decisions, I think that those decisions should be respected. Now, the risk, of course, with handing over this responsibility is that people will make the wrong decision. So a piece of legislation could contain within it very clear safeguards and protections and mechanisms. And a number of states have already gone down this particular route, where it is possible, for example, to build in safeguards and protections. Now, I would never be so naive as to suggest that all protections and safeguards will prevent abuse or will prevent a person making the wrong decision. And of course, as we go through life, we do make the wrong decisions in life on occasion. And fortunately, most of the decisions that we make don't have the same types of consequences as a decision to have, for example, assisted suicide. Does that mean, though, that we should not provide for it? I would argue that that is not a sufficient reason. And the reason why I make this particular argument or proposition is that if we were to work on the basis that people can make the wrong decision, or, for example, expose themselves to a situation where there is a risk to them of this type of nature, then every child that was born would never walk out of a hospital. We keep them there. Why would we keep them there? Because ultimately we know it's a big bad world out there, and there's always risks, particularly for children and for everybody else. But obviously we don't do that. We recognise that people do have rights and entitlements. And I would suggest that in this particular situation, that people should be entitled to exercise that particular right. So I would counter the argument that that the issues of slippery slopes and floodgates is that we can restrict the right. And I think we do have to restrict the right in circumstances. We live in a country that currently has an exceptionally high rate, for example, of suicide. So it's not wild abandonment I'm suggesting. I'm suggesting that we can provide for this particular right and that we can make and ensure that that right has safeguards built into it. I think the other thing is that people, when we talk about this issue, forget something. Because there's an automatic assumption that if you build a right like this, or you create a right, or you create legislation that recognises some type of legal entitlement, the first thing people are going to do is there's going to be loads of people queuing up for it. Okay? I spent a lot of time with people who are, I work with clinicians, and I've also spent time with people who are terminally ill. Do you know what? They don't want to die. So there's this idea that if you create this right or entitlement, people will automatically jump into it, and that will be what will happen. The reality is that people don't want to die. And that a decision that a person makes such as this is a decision that I think in life is taken in the vast majority of cases in light of very, very serious consideration. And if people have any hope of living a decent quality of life, most people exercise that particular decision to live that life. I suppose the other argument that people raise about this is, and it comes much more from a religious perspective, is the whole issue of damaging, for example, the sanctity of life. That this is a principle that we should uphold. And I recognise that it is an important principle, and it is a principle that is deserving of respect. It has to be respected. And the only thing when I come back to this, when I think about it, is, well, there is the sanctity of life from a very objective perspective. When we think about the sanctity of life, we also should think about it from a subjective perspective, because it's the quality of that person's life that's at issue. And there's always an issue that when we talk about the sanctity of life, that are we talking about it in an objective way or a subjective way, and also, are we taking this particular objective view and then imposing it, or people imposing a particular view of what the sanctity of life is? Because in many cases, that's maybe what we're doing. We're imposing a particular view as to what we think life is about, and what we think, how, for example, that an individual who doesn't want to live life anymore, who's in extremis, has to, for the purposes of upholding our value of sanctity of life, must be maintained at all costs. And of course, that brings me on to my next point, which really is that the sanctity of life is not an absolute value. We already recognise that it's not an absolute value. So we do already allow for within our legal system and within our ethics system, we do allow, for example, for situations where people can refuse life-saving, life-preserving treatment. So we never uphold the sanctity of life at all costs. And then, of course, the issue is that if we don't uphold it at all costs, when do we not uphold it? And whose values do we apply when we don't uphold it? Because I think that's a very valid consideration. If I think we're in a situation, for example, where we upheld the value at an absolute cost, then I think the argument for, or the argument against assisted suicide is a very, very strong one. But the reality is that we do allow clinicians and patients to make decisions, and in certain circumstances, it's something that really worries me sometimes, is the decisions that are taken not about conscious and competent adults, but in fact about unconscious and incompetent adults whose treatment is withdrawn, when we don't know whether in these particular circumstances that's what the person wanted. So I think that the sanctity of life argument is important, and I recognise it, but I also recognise that we don't hold it to an absolute value. We don't do that. And if we don't do that, then I think there's a problem with putting forward a proposition that we shouldn't allow for assisted suicide. The other sort of final sort of plank of my argument, as it were, is the reality is that this is already happening. The idea that it's not happening is exceptionally naive. If we were to examine what happens in other jurisdictions, what we do find, research that's carried out even in jurisdictions where it is not permitted or regulated, surveys of clinicians and families indicate that there are circumstances where assisted suicide occurs and takes place. And my argument would be that if that is the case, surely, and we've already got, for example, got 2 cases in Ireland involving issues in relation to, at least 2 cases involving assisted suicide, that if that is the case, that we need to recognise that it's happening, and we need to provide, surely it would be better for us to provide a mechanism whereby we legislate for it and we create safeguards in order to ensure that it doesn't happen in circumstances where it shouldn't happen. So, in conclusion, I would argue that there is not only does the Parliament have an ability, as recognised by the Supreme Court, to in effect bring in assisted suicide legislation, but I also think that we should have a situation where they are under a responsibility to undertake at least a scoping exercise as to whether in fact we should have assisted suicide legislation. I know that Tom has had a number of TDs talk on his behalf or raise the issue in the Oireachtas. Unfortunately, they don't come from the main political parties. They came from independents. And one thing that I wonder about is the extent to which the mainstream political party, what's worrying the mainstream political parties about talking about this particular issue and debating this particular issue in things. So in conclusion, I think we should legislate for assisted suicide. Thank you. Thank you very much.
Thank you, Adam. Now, in opposing that motion that Ireland should legislate for assisted suicide in response to the Fleming decision, I'd like to introduce Dr. Donal Mathuna. Donal is an author. He's also an academic at Dublin City University's Department of Nursing and Health Sciences. He has written extensively on issues of euthanasia. He's had papers produced in Ethics and Medicine. One during the 90s did St. Paul condone suicide, implications for assisted suicide and active euthanasia. He's also the co-author of Basic Questions on Suicide and Euthanasia, Are They Ever Right? And that was a production in 1998. And so, opposing the motion, I'd like to introduce Dr. Donal Mathuna.
Thank you very much for the opportunity to engage with you on this very important issue. So, members of the audience, Adam, Mr. Curran. This is a very challenging topic, and yet I think Adam has made it very clear, a very important issue to be addressed. I think it raises some of the core issues that